Defense counsel for the accused person.
May it please the Honorable Court. F.S. Jimba. And I appear for the accused person.
Medical kindly confirm to this court that the accused person is fit to stand his trial.
Good morning, my Lord. My name is Sergeant Ali Zakari from DHQ Medical Center. The accused soldier, Last Corporal Babangida Ibrahim, is medically fit to stand trial.
Yes, sir. Now, listen to your charges. Count 1. Made under the Armed Forces Act, Chapter 20, Laws of Creation of Nigeria, 2004. The accused person, 08-NA/61/2672. Last Corporal Babangida Ibrahim, being person subject to military law discharges. Count 1. Statement of offense, committing civil offense by virtue of Section 114 of the Armed Forces Act, Article 20, Laws of Creation of Nigeria 2004. That is to say, culpable homicide not punishable with death, contrary to and punishable under Section 224 of the Penal Code, Cap P3, Laws of Creation of Nigeria 2004. Particulars of offense, in that you, Last Corporal Babangida Ibrahim, while deployed on Operation Mercy at Anka local government area of Zamfara State on or about 10 August 2014, without justification, shot at Mr. Bello Aliu Abdullahi with your personal AK-47 rifle with registration number QQ4461, thereby causing his death. Do you understand this charge?
Yes, my lord.
How do you plead? Guilty or not guilty?
I'm guilty, my lord.
Guilty or not guilty?
I'm guilty, my lord.
11 August 2014, with intent to commit an offense, broke into the accommodation of Mr. Bello Abdullahi Ali. Do you understand this charge?
Yes, my lord.
How do you plead? Guilty or not guilty?
Guilty, my lord.
Count 3. Being a person subject to military law is charged with statement of offense, theft, contrary to Section 286 of the Penal Code and punishable under Section 287 of the Penal Code, Cap P3, Laws of Creation of Nigeria 2004, triable by virtue of Section 114 of the Armed Forces Act, Cap A20, Laws of Creation of Nigeria 2004. Particulars of offense, in that you, 08-NA/61/2672, Last Corporal Babangida Ibrahim at Gidandari, Anka local government area of Zamfara State, on or about 11/0400 August 2014, took Gioni E3 and a Nokia handset phone belonging to Mr. Bello Abdullahi Aliu with intent to permanently deprive him of the properties. Do you understand this charge against you?
Yes, my lord.
How do you plead? Guilty or not guilty?
Guilty, my lord.
Count 4. Being a person subject to military law is charged with statement of offense, theft, contrary to Section 286 of the Penal Code and punishable under Section 287 of the Penal Code, Cap P3, Laws of Creation of Nigeria 2004, triable by virtue of Section 114 of the Armed Forces Act, Cap A20, Laws of Creation of Nigeria 2004. Particulars of offense, in that you, 08-NA/61/2672, Last Corporal Babangida Ibrahim at Gidandari, Anka local government area of Zamfara State, on or about 11/0400 August 2014, dishonestly took Honda Accord car with registration number TRK 414AA containing one HP laptop computer and the sum of 6,000 naira only, all belonging to Mr. Bello Abdullahi Aliu, with intent to permanently deprive him of the properties. How do you plead? Do you understand this charge against you?
Yes, my Lord.
How do you plead? Guilty or not guilty?
Guilty, my Lord.
The court can enter a plea of guilty on them, and if there's a locus from the defense, here, my Lord. 1972 requires that after the accused has pleaded guilty to a charge, the prosecution will now read an abstract of what happened and tender the statements he would have used if the case had gone on full trial. My Lord, the accused officer, soldier, was charged for culpable homicide. My Lord, while deployed in Zamfara, in Anka local government, on or about 10 August 2014, my Lord, he went to one Mr. Bello Abdullahi's house, brought him out, and killed him without any just cause. My Lord, after killing the civilian, he went back to the house of the civilian, took his Honda Accord car, took his phones, and his laptop, which was inside the car. He drove, went to Kaduna from Zamfara, and parked the car. My Lord, was in the process of looking for the deceased that investigation revealed through the phones of the deceased, which the accused soldier had converted to his own personal use. And men of the Director of State Security Service were able to trace and connect him to the killing of Mr. Bello. My Lord, during investigation, statements were taken from the accused soldier. My Lord, we have the voluntary statement of the accused soldier, that's Compa Ibrahim Babangida. We also have the voluntary statement of Miss Paul, dated 28/10/2014. That was the lady where he went to park the car. Her statement is also before this honorable court. We also have the interrogatory statement of the accused soldier. And my Lord, we want to tender all these as exhibits before the court. My Lord, we also have, normally if this court would have gone for full trial, we would have moved to Kaduna to what we call the locus inco. That is the visit to where the crime was committed and also to see some other exhibits because the car belonging to Mr. Bello had been parked in one Dick Provost company for the past 7 years since this case began. So we couldn't bring it as an exhibit, but it's not an issue here. But we want the court to be aware that that item, it's an exhibit before this court. My Lord, we want this honorable court to accept and mark all these exhibits as exhibits before this honorable court, my Lord. Thank you, my Lord.
We have no objection to.
The military cautionary statement form 51A, made by Lance Corporal Noah Christopher, dated 26 October 2014, tendered from the bar by the prosecution, is hereby admitted in evidence and marked as Exhibit B. Civilian voluntary statement form 51B and interrogation form made by Christiana Paul, dated 28 October 2014, tendered from the bar by the prosecution, are hereby admitted in evidence and marked as Exhibit C1 and C2. Additional military cautionary statement form 51A and interrogation form made by Lance Corporal Inowa Christopher, dated 26 October 2014, tendered from the bar by the prosecution, are hereby admitted in evidence and marked as Exhibit D1 and D2. Defense, any plea of mitigation, plea of allocutus.
It is a very solemn moment because we are dealing with an offense that involves the loss of life. And our allocutus is not in any way intended to trivialize the life of the deceased. And it's on this note we want to also officially and formally extend our condolence and apology to the family of the deceased that are here today. Having said that, my lords, in every criminal trial, the end is always an acquittal or a conviction, and a punishment follows. But my lords, the punishment is not the end in itself of a criminal trial. It's only a means to an end, and the end is to transform and reform the accused person so that they can be useful to society. Today, I want to draw the attention of your lordships that the first step to reformation and transformation is, first of all, an admission that I was wrong, which is what we have witnessed today. So in arriving at the sentence, I would urge your lordships to consider the fact that the convict before you has already begun the journey to transformation. Secondly, my lords, I would like to urge on the honorable court the fact that the convict is not a habitual criminal, but a human being who the errors of humanity has happened to. And so in arriving at your sentence, my lords, we urge you to note that the convict is a first-time offender that has never had any history of crime or indiscipline. Thirdly, my lords, the convict before you is a family man, and his family is also here today. He has 3 very young, impressionable children. And though the circumstances we are faced with are those that he should bear responsibilities for, however, those responsibilities will have a way of affecting the lives of the young ones and innocent ones. So it is our plea that in doing justice you will consider mercy. We plead that the charge under Section 222 of the Penal Code has granted to your lordships a leverage to consider circumstances in which you may be able to be persuaded to be lenient and merciful in your sentence. And we urge you accordingly to temper justice with mercy. Thank you, my lords.
At this stage, this court will rise for 1 hour, and then we'll come back to give our findings and subsequently award punishment. Arise. Having listened to the prosecution and the defense counsels, findings and award of sentence in the case of Nigerian Army versus Lance Corporal Babangida Ibrahim. The accused soldier, 2008 NA, /61/2672, Lance Corporal Babangida Ibrahim, was charged on 4-count charges before this General Court Martial. The offenses upon which he was charged were as follows. Count 1, committing civil offense by virtue of Section 114 of the Armed Forces Act, Cap A20, Laws of the Federation of Nigeria, 2004. That is to say, culpable homicide, not punishable with death. Contrary to and punishable under Section 224 of the Penal Code, Cap P38, Laws of the Federation of Nigeria, 2004. Count 2, housebreaking, contrary to and punishable under Section 110 of the Armed Forces Act, 2004. Count 3, offense of theft, contrary to Section 286 of the Penal Code and punishable under Section 287 of the same Penal Code, 2004. Triable in this court by virtue of Section 114 of the Armed Forces Act, Cap A20, Laws of the Federation of Nigeria, 2004. Offense of theft contrary to Section 206 of the Penal Code and punishable under Section 287 of the Penal Code, triable in this court by virtue of Section 114 of the Armed Forces Act, 2004. In all this, statements of offenses, the particulars of the offenses were provided in the charge sheet. The accused soldier, upon arraignment, pleaded guilty to the 4-count charges. The prosecution counsel gave a brief summary of the facts of the case before the court and tendered 6 documents from the bar. These documents were not objected to by the defense counsel, and they were all admitted in evidence and marked as Exhibit Alpha, Bravo, Charlie 1, Charlie 2, Delta 1, and Delta 2, respectively. Thereafter, the defense counsel made a plea in mitigation for the accused soldier. He prayed the court to consider the essence of punishment, which is to transform, and prayed the court to see the plea of guilty by the accused soldier as the beginning of his transformation. He also appealed that the accused soldier is a first offender who is not an habitual criminal. He informed the court that the accused soldier is married with children and pleaded the court to temper justice with mercy. Having listened to the plea of mitigation of the defense counsel and the submission of the prosecution counsel, this General Court Martial finds the accused soldier guilty as he earlier pleaded on all the 4-count charges. It is noteworthy that military justice system is like other justice systems. The General Court Martial has a sacred duty to ensure that justice prevails by doing nothing but substantial justice, which is justice for the society, state, and institution, justice for the accused, and justice for the soul of the deceased. His spirit is appealing to God for vengeance. In this particular case before this court, there is an amount of sentence there is no amount of sentence that will be commensurate to the life that has already been lost. However, the court holds the institution the responsibility to dispense justice for the interest of all. Therefore, this General Court Martial, having found the accused soldier, 2008 NA/61/2672, Lance Corporal Babangida Ibrahim, guilty as he earlier pleaded, hereby sentence him as follows. Count 1. Unculpable homicide, not punishable with death, contrary to and punishable under Section 224 of the Penal Code, Cap P3, Laws of the Federation of 2004, is awarded 40 years of imprisonment. Count 2. Offense of housebreaking, contrary to and punishable under Section 110 of the Armed Forces Act, is awarded 5 years imprisonment. Count 3. Offense of theft, contrary to Section 286 of the Penal Code and punishable under Section 287 of the Penal Code, 2004, and by virtue of Section 114 of the Armed Forces Act, is also given 5 years imprisonment. Count 4. Offense of theft, contrary to Section 286 of the Penal Code and punishable under Section 287 of the Penal Code, Cap P3, Laws of the Federation of Nigeria 2004, triable by virtue of Section 114 of the Armed Forces Act, is given 5 years imprisonment. Count 2 to 4 are to run concurrently. This judgment is, however, subject to the confirmation by the confirming authority. This judgment is dated today, 12th August 2020.
Sentences just passed. Thank you very much, my lords.
May we request the Honorable Court that the convicted soldier should be discharged from the dock.